year. And my vice chairman over here, Ms. Jamie Herrera Butler of Washington, and Kevin Yoder of Kansas, and Mr. Amadei of Nevada, Mr. Serrano of New York, and another great Georgian, Mr. Sanford Bishop. I want to thank everybody for being here. I think we're going to have a pretty good hearing today, and look forward to hearing from our guest. But I appreciate the dedication and attention to the important issues that we face as a subcommittee, and to all our members, and the commitment that they've made to this committee and the work ahead. But as we get started, I do want to recognize we do have a new clerk for our committee for this year, Dina Barron, who's had to hit the ground running. It's been a sort of a unique year dealing with the funding bill previously, the FY17, and wrapping it up. She did a fantastic job, and along with our good team we have. But we also have the newest addition is Brad Allen, who's just joined the subcommittee staff this week. So Brad, welcome. I look forward to working with you. And then, of course, the former chairman, Mr. Crenshaw, we miss him, but we certainly recognize that he is now in a better place. He's enjoying life on the golf course, most likely today. But now on to business, and just for our members here and for our guests, this is like many of the committee meetings we've all had before, where we're going to just sort of loosely adhere to a 5-minute rule if possible, as we have a good discussion and dialogue, and that's sort of a combination of time between question and answer, if we can do that, but plenty of time, I think, for everybody to exhaust questions and work through the answers. And so the more that we can adhere to that, I think the little bit better it is for everybody as we work through the process. So as we get started, Judge Gibbons, thank you for joining us. It's good to see you again. I appreciate the time and the visit that we had previously a few weeks ago. And I didn't realize that this is your 12th time appearing before the subcommittee. That's an impressive track record there. So thank you for your commitment and for what you're doing for the courts. We appreciate your dedication and your willingness to meet with not only me, but I know with other members. But we also have Director Duff. Welcome back as well. And I understand this is your second stint, which is pretty unique as the Director of Administrative Office of the U.S. Courts. But it's your 7th appearance before this subcommittee, so that's no small feat in itself. We appreciate your endurance of coming back. So thanks for being here. Now, a fair and independent judiciary is a cornerstone to our democratic system of government. And as our third branch, the judiciary is responsible for resolving criminal and civil cases, as well as some bankruptcy disputes. The courts must have the trust and the respect of our citizens to function as the founding fathers intended. Not only do the courts serve as the arbiter of justice, the judiciary's probation and pretrial service officers perform a critical public safety mission by supervising more than 200,000 offenders and defendants living in our communities. Those are our communities that we represent here today. The judiciary's fiscal year 2018 budget request proposes a discretionary spending increase of $274 million, or nearly 4% above last year's. I'm interested in hearing from you today, as are all the committee members, and learning more about the budget needs and what makes up that request. In addition, I look forward to working with you and Ranking Member Quigley to continue to identify savings in the federal judiciary's budget. You've done a fantastic job over the years, and look forward to those creative efforts in the future, and with the resources but obviously that you need to fulfill your constitutional duties. And since my Rome office shares an address with the federal courthouse in that community, I'm very familiar with and appreciative of the important work that you do and the impact you make in our local communities, and certainly look forward to your testimony this afternoon. So with that, I'd like to yield to our ranking member, Mr. Quigley, for any remarks he might have, and then recognize Judge Gibbons for her comments.
Thank you, Chairman Graves. And I want to thank Judge Gibbons and Director Duff for coming back again. Appreciate your work. Chairman Graves, for you and the members and the staff, thank you for wrapping up 17 again and beginning 18 together. And as you suggested, a well-functioning federal court system is a key pillar of our democracy and is fundamental to ensuring that the constitutional rights of all Americans are not infringed. But it cannot properly function without the support of this committee. It is crucial that we provide these courts with the resources they need to effectively and efficiently perform their constitutional duties. As a practicing lawyer in my former and more interesting life, I understand and deeply value the work that you do. The recently enacted fiscal year 2017 bill included an increase of $149 million over the prior year's discretionary appropriations, and your budget request for fiscal year 2018 continues to work to rebuild and invest in the future of our court systems. As you both already know, I believe in the adequate funding of the Federal Defender Services Program. I was pleased that Congress was able to provide an increase of $40 million for the program in 2017, but more is needed. I look forward to working in partnership with the chairman to see what we can do to support the further increase requested in your budget submission. However, as we consider this request, we must work with the new administration, which has made it clear its intention to propose a budget for fiscal year 2018 that will make deep and painful cuts to all non-defense related programs. After several consecutive years of reductions to the funding allocation for this subcommittee, any effort to further shrink the pie is sure to carry devastating consequences for the judiciary. That being said, I can assure you that I will continue to be a staunch advocate and defender of the work you do, and will do all that I can to ensure that robust funding for the judiciary remains a priority. Once again, welcome, and I look forward to your testimony. Thank you again, Mr. Chairman.
Thank you, Mr. Quigley. Now, Judge Gibbons, if you'd like to share with us some brief remarks of your statement that we know that you've submitted for the record.
About the Judiciary's fiscal year 2018 budget request. My remarks today will be very brief, highlighting our 2018 funding priorities and our ongoing cost containment efforts. Before I begin, I want to recognize a group of court executives with us today who are in town for a meeting of the Financial Managers Working Group. This group plays an important role in advising the administrative office on financial management, training, and policy matters. These are the executives we rely on the front line, and they do a great job of helping the courts run smoothly. They're in this area right there. First, I want to thank the subcommittee for the 2.2% increase we received for 2017. We very much appreciate your making the judiciary a priority. For 2018, we asked for a 3.9% overall increase. A 3.3% increase is required to maintain current services. The rest of the request is for targeted enhancements that will enable us to continue addressing cybersecurity needs and for several space-related security and other priorities. We have several cost containment efforts underway in our space and facilities program that are achieving significant savings. Our space reduction efforts to date have reduced our annual rent bill by $20 million. Successful negotiations with GSA to change the way they charge us for courtroom space will save us about $19 million per year. And we expect significant additional savings as GSA implements other changes that impact our rent bill. Cybersecurity is our top administrative priority, and we've made significant investments in recent years to improve our IT security. Our 2018 request includes an increase of $9 million to further enhance these efforts. We seek funding for increases for several space-related items, including $10 million for one-time space alterations so we can continue reducing and consolidating space where possible. $10 million for building repairs for the Thurgood Marshall Federal Judiciary Building here in Washington, and $3 million for judiciary costs associated with several new courthouse projects. Other enhancements we request include a $6 per hour rate increase for private panel attorneys representing indigent defendants, funding to convert a magistrate judge position in Pennsylvania to full-time, and several smaller items for the court security program. In conclusion, as always, I emphasize to the subcommittee the unique constitutional role of the courts and that all of our duties are derived from the Constitution and statute. I ask that you make my statement part of the record along with the statements of the other judiciary entities on whose behalf we submit budget requests. Look forward to the subcommittee's questions.
Thank you, Judge. Director Duff, feel free to share with us your remarks as well.
Thank you, Chairman Graves and Ranking Member Quigley and members of the subcommittee. I'm pleased to appear before you today and provide these very brief opening remarks, and also to thank you for our 2017 budget. I know what a great effort that was on behalf of this committee and your staff to get that done while you're working on the 2018 budget as well. So we greatly appreciate that. As Director of the Administrative Office of the United States Courts, I'm here to present my organization's fiscal year 2018 budget request of $90.3 million. This is a restrained request and represents only a current services budget. The funding, however, is critically needed to sustain the work of the Administrative Office as it provides administrative support to court units and federal defenders, guides the Judiciary's national programs, and provides new technologies and processes to the court and defender communities to promote effectiveness and efficiency in their operations. I also appear today as Secretary of the Judicial Conference of the United States, and in that capacity, I offer my support for the overall request for the judicial branch as presented by Judge Gibbons, and ask for your support for several conference priorities that extend beyond the Judiciary's budget. The first of these priorities is the continued one-year extension of a number of temporary district and bankruptcy judgeships whose authorizations otherwise will expire during fiscal year 2018. As always, the conference is indebted to the subcommittee for its willingness to act on our extension requests, which ensure that the administration of justice in effective districts continues without disruptive delays and other burdens while we await action by the authorizing committees to create new permanent judgeships that we've requested. A second conference priority is the sufficient funding of judiciary needs within the construction programs administered by the General Services Administration. For fiscal year 2018, we identified $23.4 million of priorities for the Capital Security Program. And this is a program, as you may recall, which addresses serious security deficiencies in existing courthouse buildings where physical renovations are viable alternatives to new construction, which would be far more expensive. In addition, our top three priorities for new courthouse construction are the completion of a partially funded courthouse in Harrisburg, Pennsylvania, and the construction of courthouses in Huntsville, Alabama, and Fort Lauderdale, Florida. I understand that fiscal year 2018 is likely to be another year of constrained funding, and it surely will be a challenge for you to work creatively to meet the needs of the many agencies and programs under your jurisdiction. I thank you, however, for your continued recognition of our unique needs and the high priority this subcommittee has placed on meeting the funding requirements of our branch despite broad fiscal constraints. By doing so, you are ensuring that the judiciary continues to perform its vital constitutional role as intended and required. That concludes my opening remarks, and I would be pleased to answer your questions as well. And ask that my more lengthy statement be included in the record.
Thank you very much. Thank you for your comments and also your commitment to, under austere times, to continue to carry out the constitutional role in which you're challenged with, and I know it's been a challenge. One of the areas I know that we've discussed in a previous meeting was the space reduction plan and goals, and I think it'd be good if maybe you could update the committee, if you don't mind, on where you are as far as your target of, I guess it was 3% space reduction, and what actions you might be taking as a result of fiscal year 17 to help meet that target.
We're actually doing very, very well. It's been very gratifying to see how the judiciary has worked as a whole toward the goal of a 3% reduction by the end of 2018. We're actually a little ahead of schedule. We were at 77% of the goal, I think, by the end of 16. And I don't know if that's calendar or fiscal year 16. We think that ultimately the 3% represents about 870,000 square feet, and we actually think that at the end of the period, we're going to reduce space by an additional 200,000. So we'll do better, we think, than the goal. You'll see that there's a bit of money requested to do some reconfiguring of space. Sometimes when you cut back space, you want to reconfigure it, and particularly today when we can do the same kinds of functions in much less space. I mean, we're going to more open office settings. IT permits the reduction of space. People who are working remotely part of the time, that reduces the need for space. So it's important to us to get those reconfigured workspaces so that we can reduce the space further and fully use it.
Maybe if you could share with us how much that savings translates to, as well as some of the challenges you face in local communities, if you do, regarding any kind of pushback, because not always is it square foot reduction, but in some cases it might be a closure of a facility, and how do you navigate that and make those decisions?
Well, we have really not treated the closure of facilities so much as a part of this as we have as a separate analytical exercise. And obviously it counts if we close a facility, but that's not the strategy we're looking to get us to this goal. The strategy we're looking to get us to this goal is to have, on a circuit-wide basis, a space reduction plan. We've offered a financial incentive to courts. We're allowing them to bank space, to count it toward future reductions if they give up more than they are required. So they're really two separate strategies, but we've tried to close unnecessary courtroom facilities for a long, long time with challenges along the way. First, there's just the internal process of identifying space that we can let go. And then often there's community opposition, and it is a serious thing to remove a place of holding court from a community. Sometimes members of Congress don't like it either. So
how do you make those decisions? That's got to be challenging. Is it tied around whether a sitting judge is in place?
Sure, it's tied to the use of the facility, and if you have a facility with no resident judge and very little judicial activity going on, but that's not the only factor. For example, you can have a facility where you don't have a judge resident, but maybe you have a probation office or it's just, there are a number of different things, and it's really a case-by-case, individualized consideration.
Okay, great. Well,
Did that handle what you?
No, that's great. I know it's certainly something that I'm sure other members have heard as well, because it's a challenge to have space reduction when it does impact local communities that
Yes, it does.
represents
And we try to be cognizant of that. And we try not to be, sometimes we have to close the facility, but we try not to be heavy-handed about it.
Great. I couldn't imagine you being heavy-handed. Good Southerner. Mr. Quigley.
Thank you again. We referenced the Federal Defender Program at the beginning. Curious, what's the trend in, what percentage of people in court can't afford their own lawyer? Clearly on the criminal side, but also on the civil side.
Well,
how are the trends going?
I don't have any statistics here with me, and I'm not sure that there's a trending there. The whole time, I've been a federal judge for a long time now, since 1983, and I was in the district court the first 19 of those years. I don't know that I can see an appreciable difference in the number of defendants who require court-appointed counsel over that period of time. The fact of the matter is that a very, very tiny percentage of criminal defendants are able to retain counsel. Some can, and sometimes we can appoint an attorney and have the defendant who is somewhat able to pay but not fully able to pay reimburse the government for a part of the cost of his representation. But that doesn't happen very often. We can certainly provide you with figures, but I'll tell you it would be, from my experience, it'd be a very tiny number who can retain counsel.
Second, transparency in the judicial system. Obviously, this involves the internet-based PACER system, which provides courts, litigants, and the public with access to court dockets, case reports, and the millions of documents filed with the courts. I'm aware that some users, but not all, are charged a fee for usage, and that your budget is projecting revenue of about $145 million for 2017. Can you please discuss how the PACER system is funded and the rationale behind the current approach? Is there a reason to believe that the fees serve to impede access for individuals or organizations that are seeking info? And finally, are there opportunities to improve or expand PACER so that it can function more effectively as a public service?
Well, thank you for the question, Congressman Quigley. I think it's on the minds of a lot of people, and we certainly are firmly committed to transparency in the federal judiciary. And the history of PACER is an interesting one in that our appropriators, I think wisely, advised us to charge a user fee for its use to offset what otherwise would have been a budget request appropriated funds that we would need to add to our budget. And you're exactly right about the projected funds collected at $145 million this coming year. 90% of the fees that are paid into PACER are made by 3% of its users, and those are large institutional users, the LexisNexis of the world, and they pay the bulk of those fees. 60% of the users of PACER pay no fees whatsoever. So it is, we think, very accessible. Could it be more so? We're happy to look into that and work with all involved, but we have received some questions from members of the Judiciary Committee in that regard, and I would I'm trying to facilitate and encourage communication between our appropriators and the Judiciary staff on this point, because it's an important one. We want people to have access to the court documents, and we think it's structured wisely at the moment because of the fee structure, and it's not particularly onerous to those who seek to use it. As I mentioned, 60% of the users are not paying any fees at all.
And what percentage of filings now are electronic? It's trending. There is a trend there, I understand.
Yes, it is up.
Requirements.
I don't know the percentage off the top of my head, but we could find out.
I think we'd have to check on that as well. But my impression is that virtually all courts have fully implemented electronic filing. Now, obviously, provisions have to be made and will always have to be made for litigants who do not have access to computers, who can't file electronically. But I think virtually all courts have converted. Perhaps I'm wrong, but I think that's right. I think that's right.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Quigley. Vice Chair Herrera Butler.
Mr. Chairman, and bear with me. I have a few questions, and some of it's just going to be understanding related. My predecessor, some years ago, so I'll tell you a little context. I'm in Southwest Washington State, which is, in terms of, I've followed this conversation about closing with interest because, you were talking about use of a facility as part of it, and if there's a sitting judge, and, is there little judicial activity or high? We don't have a federal courthouse, or there's a magistrate who comes, but we don't have a federal sitting judge. And then obviously the U.S. attorneys are up in Seattle. So there's a Seattle and a Tacoma office. And my predecessor worked very hard on trying to bring attention to this and hopefully perhaps opening or expanding so that, litigants in our area don't have to drive 2.5 hours north. You can make brief appearances at our federal building, but obviously resolution has to take place at a federal courthouse, and even down to simple things like being called to serve on jury duty. A lot of folks have to try and get out of it because it's not a hop, it's not even 45 minutes away. It's not an hour and a half away. It's 2 hours plus away. And I was curious what your specific criteria are in terms of population, usage, what is little judicial activity, or what is heavy use or little use of the facility, and is there a population? And I should mention, we're on I-5, so we're Canada to Mexico. So it's of particular importance to me with regard to, we're seeing an increase. We've been working on it. Local law enforcement is working diligently with regard to gang activity, drug crimes, human trafficking. It is on the increase in our region. We're not off the beaten path. You have to go right through us to get, Mexico to Canada. So it's an issue I don't think will go away. So I was hoping you could speak to that a little.
I think that, and you can chime in on this if you happen to know more about it than I do, but I believe that all places of holding court are statutory.
I think you're right. I was hoping you would know for sure.
I'm pretty sure that's right. I know that when the district court on which I served closed a facility at Dyersburg, which was similarly inconveniently situated to Memphis, where I was, but we never had trials there. I think that required a legislative change. So the impetus may come, if it's a place of holding court, the impetus may come from the court, but it may require participation elsewhere.
Well,
But if you're talking about creating a place of holding,
and the impetus, like what goes into it? What is? I can understand why you would narrow down a place that doesn't get used a lot, and you're trying to repurpose.
Right.
But it's going to go the opposite direction in other areas. What is behind? How would you come to us and make that request, or how would that look?
One of the factors certainly would be the caseload of the judges in the sitting courts that are nearby, and we use a formula for a request for new judgeships, which we've done, 430 cases a year per judge is our norm, and that's where we would say any more than that justifies the request for a new judgeship. So that would go into the mix even for courthouse location if you look at the caseload in a particular jurisdiction or area. That's a factor. We have made requests for 57 new judgeships based on caseload that we have around the country. We have courts, we have judges in some of our border courts in the Eastern District of Texas. They're carrying over 1,000 cases a year, which is an impossible caseload. So we have requests pending for additional judgeships in instances like that. And it also occasions our requests for temporary judgeships where we know the caseloads are up in certain. So that's one of the factors that would go into consideration.
It's not necessarily based on population. It's
part of it, yes. I'm sure that's a factor for the statutory basis of creating a courthouse and a judgeship, certainly.
I think, though, that in general you'll find that the adjustments of that type do, in fact, lag behind population, because you wait and you get to the point where, there's so many people in this area who weren't there before that at some point somebody starts thinking about how are we serving these folks with the availability of a federal court. But, you think about it, the country changes all the time, population changes, And I think would be true to say that the places of holding court don't keep up with that.
Thank you.
Thank you, Mr. Herrera Butler. Mr. Serrano and then Mr. Stewart.
And welcome to you both again.
Thank you.
Our President and the Attorney General have been very vocal about the need to increase criminal prosecution of immigration violations, rather than letting them go through the administrative court process set up at the DOJ. This is an odd decision given that 52% of federal criminal cases are already immigration-related. Has the Department of Justice discussed the impact of these potential changes on the federal defender system? And another question, how much strain would an increased caseload have on federal defender offices? And have you budgeted in anticipation of that?
Our budget request does not include funds for that because we think it's premature to measure the impact. But we would certainly want the subcommittee, as it considers our request for this year, to realize that we very likely will face a need for additional resources. Criminal immigration enforcement, of course, increases the strain on the border courts. And although there's been some decline in the border court caseload, they are still very heavily burdened already. There's also civil immigration enforcement, which involves our courts of appeals, because decisions by the Bureau of Immigration Appeals go to appellate courts like the one on which I sit. You know, there's also, I'm not sure if you were asking only about immigration, but of course the recent announcement of a change in charging policy to charge the most serious offense that can be charged with the most severe sentence. That impacts both immigration enforcement and other criminal cases, and that would be a big, possibly a large resource impact on the federal courts. But we don't like to ask for money when we don't know how much we need yet, and we know it'll take a while for the effects of those policy changes to be felt. So we'd hope you'd fund us this year in a way that would not put us down in our efforts to encounter dealing with those challenges. And in the future, we may well need to ask you for more resources.
And I would just agree, of course, but also add it clearly is going to have an impact on our budget ultimately, and increase prosecutions in that way.
And I think you asked about defenders specifically.
Yes.
Of course, it'll increase representations. And so while the defender representations have been down somewhat, you know, we can expect those to increase. And we're already on an ongoing effort to try to get the defenders funded under formula. We haven't asked for additional positions for this year because we anticipated that the 17 funding would be late. And we knew, I mean, there's just a certain number of people you can bring on in a given year. And we knew that the defenders would be needing to fill those 17 positions into 18 in all likelihood. So we didn't think it was wise to ask for more positions for 18, but we're going to have to look at that as well down the road.
Since you mentioned the new desire to be more tougher on sentencing, let me just ask you a question. Not being a lawyer, forgive me if this is not a great question, but will this be done, what the Attorney General spoke about, under existing sentencing guidelines, or will new guidelines be provided to make this, take this tougher approach?
I believe it will be done under existing guidelines. I don't think that I wouldn't anticipate any new guidelines. You know, after the Supreme Court decision in this area. Judges have more discretion with respect to sentencing than they used to. So I would not think that there would be a reason for revising guidelines that's occasioned by this decision. Where you'll see it perhaps is in seeing more people charged and charged with more serious crimes. The prior administration, I think, had taken a position that it would not prosecute some nonviolent, low-level drug offenders. And of course, many of those had not been prosecuted in the federal system anyway. I mean, most of the defendants in federal court have historically been pretty tough people. And so I'm not sure how much impact that had, but there will be some impact from the new enforcement. Although that rule is not any different from the rule that prior attorney generals have had during much of my tenure as a federal judge.
Thank you, Mr. Chairman.
Thank you, Mr. Serrano. Mr. Stewart, then Mr. Cartwright.
Thank you, Chairman. To the witnesses, thank you. It's always fun to look through the witnesses' resumes. You know, Judge Gibbons, I see, you know, UVA, great school, Order of the Coif, Virginia Law. You, Mr. Duff, magna cum laude, Georgetown, honors with distinctions. But the coolest thing is this walk-on the Kentucky basketball team. So let's talk basketball for 5 minutes instead.
Well, I should apologize to my friends from Utah on a couple of past experiences.
That's okay. We're kind of used to it. So. Hey, my brother's a federal judge out in Salt Lake. I've learned from him and watching his experience. I have a couple questions. I want to go through them quickly because I'd like to get to them both if we could.
Yes, sir.
Cybersecurity, I sit on the Intel Committee. We spend a lot of time looking at that. We were reminded of it recently. You know, even in my brother's case in district court in Utah, some of the cases he deals with are tens of millions, some cases billions of dollars, hang in the balance depending on the case. You know, you can imagine that's a target. Tell us quickly what you're doing to protect the courts from cyber.
It's currently our top administrative.
I noticed that. You listed it as your top priority.
And we have, we've asked for funding for 18 of $85.5 million. We have spent, you know, we'll have spent through 17, 72.5 million plus 15.8 million in carry forward.
So what does the 85 get us?
Well,
And on a scale of 1 to 10.
I can't tell you very specifically because obviously
that's
we
a
don't want to
technical.
come into a committee and talk specifically about what we're doing. But we have a kind of a three-pronged strategy. One is prevention. Two is detection, analyzing, and mitigating intrusions. And three is changing our culture to make folks aware of what they're doing and how to take proper cautions. Number three is our job.
Yeah.
And we think significant resources will continue to be required for several years to adequately address 1 and 2.
Do you think you're making progress on 3 where people are realizing that this is a real threat and can?
Yes, folks at the AO are being, and folks in the committee structure, judges in the committee structure of the conference, we have an IT committee, are being very active messengers for the need to do some things differently. You know, sometimes folks don't listen, but we're getting the word out.
Yeah. Okay, well, let me comment on that quickly and then go to my second question. You know, if you were to take the number of cyber attacks that we experience generally, I'm not talking the courts, but generally, you know, a year ago you shoved that thing in a bread box. Today you put it in a football stadium, and you probably know that. And so keep at it, will you please? And you have a small enough organization, you know, nationally, it's still relatively small, that you can, I think, be effective in protecting yourselves. And I hope you can and you will.
Well, we've been real careful about various IT initiatives in the past, and we haven't had any real mess-ups, and we are striving real hard to do this one right, too.
very quickly, if we could, a minute, 19 seconds. Sequester hurt a lot of agencies. I'm aware, again, primarily through my brother's experience. It was tough on the courts. We're a couple of years removed from that now. Are you back to where you need to be as far as some of the elements that impacted you very directly because of sequester? And again, I'll use his experience. He was, there were vacancies that were left open. They were forced to rent in some cases where they preferred to purchase in some real estate transactions, other things. Are we back on track from that, do you think?
We're back on track, and Jim may want to comment on that too. I will say that our court managers are very, very prudent, and if anything, they are very reluctant to spend the money they have because they run scared a bit of the time, and that is the reason we've been able to have significant carry forward that benefits us and you all because you don't have to appropriate the funds. But we've got adequate money right now to do what we need to do. Okay. Every year's a new challenge. But
and Jim, you're nodding your head. I'm assuming you agree that.
Yes, sir, I do. And again, we want to thank you and the hard work you put into getting the 2017 budget done, because that made a big difference to us and makes a difference going into 18.
Yep, thank you.
Grateful.
And now we start again on 18. Chairman, 5 seconds over.
Great job.
I yield back.
No, great job. Thank you, Ms. Stewart, Mr. Cartwright, and then Mr. Young.
Thank you, Mr. Chairman. And thank you to our witnesses for coming here today. Judge Gibbons, Director Duff. Judge Gibbons, I noticed that one of your jobs at the Judicial Conference is to supervise the director of the AO. How's he doing so far?
well, he does great, but that's not my job.
No.
That's the Chief Justice and the Executive Committee.
Very good.
I hope this is transcribed. No, I'm kidding. She's great.
I have a question. We're asking for a little bit more money this year, and you've detailed some of the areas where you need it. Overall, is there an increase in filings, in criminal filings and civil filings? I mean, it seems, and forgive me, I may have missed that in the submissions.
No, but the request for the increase really doesn't arise from that. I think you may have heard me say 3.3% of the 3.9 is for current services, and it's kind of hard to know why our filings can be flat, and we still need more money. But I think we have to look at a number of different pieces.
I don't mean to put you on the defensive at
Oh,
all.
you're not putting me on the defensive. I'm prepared to answer this. I thought about it.
But the filings are flat?
The filings are flat, and I mean, I'd love to tell you all the reasons that doesn't produce necessarily a decline in funding requests.
No,
you want us me to
understand that.
spare you? Okay.
I can spare you that. What about MDL filings, multi-district litigation? Has that been flat as well, or is it going up or down, or do you have an impression?
It's been flat. I think it's episodic, but there are some very big cases in the pipeline and somewhat hard to predict. But I know there are some rules changes that have been proposed.
That's where I'm going, Director Duff. And Judge Gibbons, I want you to weigh in on this too. There have been, here in Congress, they've been talking about very much constraining the jurisdiction of state courts for class actions. In other words, federalizing many class actions, a huge proportion of the class actions going to federal court. What effect would that have on your budget requests, if any?
I think, I'm not sure. I can tell you about the MDL cases. The MDL cases start out as a regular case in a district court.
Certainly.
So they are included in the filing figures I've got. But we don't have any, I mean, we can get it, but we don't have any separate information today, I don't believe, on the MDL docket. The federal courts are not pushing for that federalization, nor am I aware of a conference policy opposing it.
It's under study right now. Actually, our Fed State Committee of the Judicial Conference is taking a look at the proposed legislation and may well weigh in on it, but there is no articulated position at the moment on it. But
Would you agree that it is fairly axiomatic that if we federalize all the class actions, your requests for budget money will go way up?
yes, it would be.
It would produce an increase, but way up, I don't know.
Okay. Congressman Serrano was talking about cybersecurity a little bit, and in light of your request for additional money for cybersecurity enhancements, which of course makes sense, in light of last week's ransomware attack and your testimony in the matter, can you go into more detail as to what kind of cyber threats the judiciary is seeing? Is it identity theft? Is it ransomware? Are there interruptions to PACER, the online filing system, or something else? Do you have information as to where these attacks may be originating?
Our IT people might be able to give you more information on that. I have information about the increase in numbers. We've gone from, there's been over the last several years, there's been a 50% increase each year. We've gone from 4 million in 2014 to about 11 million now. Many of the intrusions have been thwarted. A few have done actual damage. We have
I'm sorry, 11 million attacks, is that what you're saying?
11 million efforts, not successful attacks, but 11 million incidents of someone trying to get into our system. We have been very fortunate so far. We've not had any system that has had any incident that has caused a major disruption, but we realize that we're as much a target as other business and government entities, and we know that there's much more that we could do in terms of prevention, in terms of analysis, detection, and so we've ratcheted it way up on our priority list over the last 12 months.
Well, Mr. Chairman, thank you for your indulgence. I yield back.
Thank you, Mr. Cartwright. And as we go to Mr. Young, there will be additional time if there's need follow-up on any questions or any additional questions you didn't have time to squeeze in that very fast 5 minutes. So, Mr. Young.
Thank you, Mr. Chairman and Ranking Member Quigley and my colleagues. Thank you for being here today. And cybersecurity is a popular issue these days for all the wrong reasons, though, right? And I'm glad you're taking it very, very seriously. You know, I was looking at your testimony, and you were talking about, Judge Gibbons, about the targeting of judiciary systems and judiciary networks. I'm curious about the terminology. Are there differences? Do you have more than one system or networks? Because in talking with some of the other agency heads and heads of commissions and bureaus, some of the systems are really antiquated, and they're trying to get them up to speed. It's like going from analog to digital. And I just am curious about how the systems are working together, and if it makes sense to have more than one system or multiple systems, and if you're...
I'm not an IT person, but I can tell you, I can answer your question in part. The reference to systems plural is probably a reference to the fact that we have an HR system that's computerized. We have a financial system. I mean, we have different systems that perform different functions within the judiciary. We have an e-voucher system that we use for Criminal Justice Act vouchers. And then, of course, we have an overall network of email and, word processing and various and sundry other functions. Virtually, as I said, virtually all courts have gone to electronic filing. Virtually all our communication among ourselves, for judges at appellate courts at least, is electronic. You
And
know,
so do you have a chief information officer or chief technology officer who kind of heads up all this and walks you through the vulnerabilities, the prevention, the testing, the
there's
best practices?
personnel in the administrative office,
yes.
which Jim can tell you about, but then each court has its own IT staff, and we're in the process of adding a cyber specialist in each court.
Yes, and the administrative office, as you know, is centrally located here in Washington, and we have an IT division and head of that, and he coordinates our policies nationally in coordination with the circuits, and we have developed a much stronger, we think, communication among the circuits about the needs and getting everyone unified as to the defenses that we're employing.
And we have a committee of judges that makes policy recommendations to the judicial conference. So, that'd be my counterpart.
And so when these nefarious groups out there try to hack into your system, what do you think they're trying to do? Just aside from the usual getting personal information of people and family members, but the case-sensitive information, what do you have a feeling that they're trying to penetrate that?
I don't know that there's, well, one, it's a little awkward to talk in a public forum about some of the incidents and the attempts, but, and so we want to be careful about that.
But it's a high priority to protect that case-sensitive information.
It very much is because, as you can imagine, it's useful information to a lot of people.
And, we're accustomed, as the judiciary, to controlling the point at which our written decisions become public. It would be of real concern to us if we lost control of that through and accessed judges' deliberative functions through a cybersecurity attack.
I want to move on to another issue. Director Duff and Judge Gibbons, the federal courthouse in Des Moines is one of 8 courthouse projects funded in fiscal year 2016.
Yes.
My understanding, it's administered jointly by GSA
Yes.
and the courts, and I'm just very pleased that this is moving forward. I know the folks back home are very interested. So tell me, to what extent are the courts involved in this with the site selection, the review process? How closely do you work with the GSA on site selection? Do you have control of where the site is? Do you have agree with GSA on the final site? Do you have veto authority? How intricately involved are you?
Well, it's GSA's ultimate decision, but we are involved in the process in that we give them priorities and requirements that we have for the courthouse. But it is GSA's ultimate determination as to where they're going to locate the building.
And those requirements are pretty stringent because a lot of it's regarding safety to make sure that those within the courthouse, because unfortunately we've seen some pretty bad happenings out there, attacks on public institutions, and safety is a big concern. But those requirements are strict and adhered to, and the GSA can't waive those for any reason, could they?
I don't think they can waive them.
And I'm not accusing them of, but I just wondered.
Yes.
Okay.
I think security would be a big requirement, adequate security.
And that's certainly on our list of priorities.
Yeah. Do the courts ever come out to any of the sites and take a look at the proposed sites at all with GSA, or do
Our
you?
Space and Facilities Office in the administrative office is involved, certainly in specifying the requirements, and they review, I think, potential sites. And
We're pleased with that. We're on the courthouse project priorities list, and so we look forward to continuing to work with you. Thank you for coming up here today, and thank you for your good work.
thank you.
Thank you, Mr. Young. Mr. Bishop.
Thank you, Mr. Chairman.
And then Mr. Molinar.
Thank you very much, Mr. Chairman, and let me thank our two witnesses, Judge Gibbons and Mr. Duff, for your appearances here today. I've got some questions on two different subject areas, and I guess to some extent they may be related. First off, in the last Congress, you had requested 73 new judgeships, and of course in this budget you're requesting 57 new judgeships. And I thought I understood that you were basing that on a formula of so many judges per criminal and civil cases as far as the caseload is concerned. So I presume then that you feel that there's a shortage and you need those additional judges. And I wanted to ask you, in light of the Attorney General's recent directive to require the charging of the most serious offenses in criminal cases, particularly with regard to immigration, what impact you feel that that will have on the judiciary, both from a financial as well as a caseload perspective. And the second thing is I wanted to ask on another subject area, what impact and how does the judiciary and how do you function with regard to the Administrative Office of the Courts in assuring that there's diversity within the judiciary, whether the clerkships and the judicial positions, and what can you do to help diversify that and make sure that the bench is more reflective of the population that it serves?
You want to do the judgeships, and I'll do diversity, or I can answer both.
Well, I was counting on you to
Okay,
do the
that's
numbers of
fine.
the judgeships.
On the judgeships, you're right. There is a need for new judgeships, and we've expressed that need, and there's a formula and a calculation that goes into our determination as to where they're needed. And as I mentioned a little earlier, for example, in our border courts, the workload is extraordinary. Some judges are carrying 1,000 cases a year, and our formula, 430 cases a year is sort of the cutoff, and then after that, there's a need for a new judgeship. Your committee has been very helpful to us in meeting some of our needs on a temporary basis where our needs are greatest, where there are emergencies, for example. That goes into the calculation. But any increase in the workload of the federal judiciary will necessarily impact our budget ultimately. And Judge Gibbons was quite accurate earlier to say that we, rather than anticipate that, we try to be pretty specific in our budget request, and so it isn't necessarily folded into this year's budget request, but will any change in policies, prosecutorial or otherwise, it would impact the workload of the courts, will ultimately require us to make adjustments to our budget request. But we try to be as specific as possible with your committee, and I think those efforts have been rewarded and we're greatly appreciative of the fact that we've been given good budgets in recent years, certainly after sequestration. Diversity is something that I'm firmly committed to. Right in my in-between stints as director of the administrative office, one of the roles I had at the museum and Freedom Forum was the president and CEO of the Diversity Institute, and we worked hard on increasing diversity in First Amendment areas and from that organization's viewpoint. And I have a similar commitment here within the branch, and I know my colleagues and our judges feel that way too. As you know, the appointments process is one that comes from the executive office, and so for judgeships in appointments of judges, that rests largely with the president and that process. But we have been working hard within the branch to build up the pool of talent from which to choose
With
judges.
clerkships and the
with
like.
clerkships and participation in programs and bringing in interns into judges' chambers at an early stage in their law careers to expose them to the work of the courts and expose our judges to their work. And we can do better. We need to do better, and we're committed to it.
Do you have any role?
Well, we encourage our judges to certainly look for candidates, and I mentioned the internship program, and we participate in a diversity recruiting and outreach program that's, as I said, we can do better, but we're trying.
You know, with respect to judgeship request, we do have a formula. It's basically, I think, about 430 weighted cases per judgeship. We have courts that are carrying 600, 700, and even more weighted cases. We've had to take a long view with the judgeship request. There hasn't been a comprehensive judgeship bill since 1990, and we've had a few along the way, and we've coped by doing things creatively to help each other. I mean, there are judges from throughout the country who visited on the border to help out from time to time, and we've just had to try to use what judgeship resources we have well to get the work done.
Thank you, Mr. Bishop.
Thank you very much.
Yeah, Mr. Molinar, and then Chairman Yoder, and then there's still some questions remaining. We'll come back around. Mr. Molinar.
Thank you, Mr. Chairman, and thank you both for being here with us today. And Mr. Duff, you recently just spoke briefly, and in your written testimony, you discussed the use of temporary judges in the high-volume areas, and I believe we have one temporary judge in my home state of Michigan. I'm wondering if you could comment on how this temporary assignment impacts the surrounding community, and what are the benefits of transitioning these judges from temporary to permanent status, and how does that affect the judiciary's budget?
Well, the uncertainty of a temporary judgeship probably has some impact, but we have sought new judgeships in the case. I think there were 12 temporary judgeships, and we've sought 10 permanent judgeships out of those 12 temporary, or maybe 10 and 8. I'll get the precise number for you in just a second. But it's we again take a look at the workload and whether it's we know that it's going to be sustained over time, and the average caseload within a particular court and temporary judgeship, and we don't always request that the temporary judgeships be made permanent if the numbers don't support it. There are areas where temporary judgeships are needed, and we know they're going to be temporary because of a very high volume kind of case in a particular district or court, and so you've been responsive to those needs, and again, we're greatly appreciative of that. I think this committee plays a very large role in that. But converting it to a full-time permanent judgeship is a different calculation, and we're very careful about it when we request it.
Okay. And then if you could both comment on your cost containment efforts. You mentioned earlier some of the space efficiencies, kind of how these efforts have impacted the court system, and then also what other agencies might learn from what you've been doing to contain costs.
Well, we've been doing cost containment since I think the policy was formally adopted in 2004, and we've been doing it since 2005. And over the course of those years, cost containment's really affected every part of our budget in terms of scrutiny and changes. I think most useful thing is to look at some of the current ones. I've already talked about the space reduction effort. We also have some space-related policies that support that. One of them is called No Net New, and so that's no net new space except projects approved by Congress, like new courthouses and alterations. We have had a very successful collaborative service validation effort with the General Services Administration. And the whole point initially was for us to try to scrutinize the service we were getting from GSA to make sure we were getting our money's worth. It turned out to be a very productive and much more collaborative effort than we had anticipated. That resulted in an agreement with GSA to treat space that was in multi-story areas differently. And all of our Article 3 courtrooms have higher ceilings than normal, so we were being charged double rent for all of those. We negotiated an agreement concerning that. That sort of principle is also going to apply to other entities, and it covers things like stairwells. So, I mean, it's a common thing to other agencies. So we did negotiate something that's going to have government-wide benefits. We've also switched from a return on investment method of calculating rate to an appraisal-based method. That's going to save us money outside the space area. We, for several years, looked at all kinds of things we could do structurally to do our job better. I think that the most successful effort has been shared administrative services, where about 90% of courts are now doing some form of shared administrative services. We're looking at things like vertical consolidation, horizontal consolidation, regional service centers. All those things are under consideration. We've got I mentioned the electronic voucher system, which enables us to scrutinize attorneys' claims for fees more carefully. We've got a new staffing formula for the federal defenders that allows accountability for the first time in how many staff they actually need. It showed they needed more, actually, not fewer, but, you know, it's good to know. And we're doing case budgeting in large criminal cases at the circuit level. We have worked to reduce the excess hours for court security officers. I mean, there's just a lot going on, and I haven't mentioned everything, but it's a constant effort. We have a process for monitoring it, a process for nudging and encouraging, and the Budget Committee is responsible for doing the nudging and the encouraging, and we do that through our Economy Subcommittee.
I would just add to that from the administrative office standpoint too. When I first came on as director in 2006, we imposed a hiring freeze, which was sort of unheard of at the time. No one else was doing it, but through attrition, we reduced our numbers of staff at the administrative office of the courts over the years, and that really was working very well for us. And then along came sequestration, and everyone at the AO looked at me and said, "Why'd you do that to us?" But it paid off in the long run. And I would just reiterate what Judge Gibbons has said about a little bit about the culture of the branch. We've been at this for a long time, actually, by comparison to most, and so we're accustomed to tightening our belts. And I think we've been recognized for it. And again, we're most appreciative of that and for this committee's attention to it.
We're serious about it. I mean, judges who ultimately govern the institution understand that we're paid by the taxpayers, and although we're independent and we decide independently, we have an obligation to try to use their money wisely and well. And we don't get a pushback about that.
Great, thank you.
Thank you.
Thank you, Mr. Mahler. Now, Mr. Yoder.
Thank you, Mr. Chairman. Judge Gibbons, welcome back to the committee. Always appreciate your testimony. And Director Duff, we appreciate your hard work on behalf of taxpayers, and certainly pay particular attention to the comments you were just making about sort of trying to squeeze every drop out of every budget and really pushing hard And I think we appreciate that because we're all trying to figure out how to operate these budgets under tight constraints. And we know in many cases we're dealing with constitutional rights at the courts. And so cases have to move expeditiously. And there's timeliness matters that things have to be done, and so you're constrained by that. I want to follow up a little bit on your question and answer with my colleague, Mr. Molinar, and really highlight your testimony regarding temporary judgeships. We've talked about this a number of times when you've been before the committee. In your testimony, you highlight the continued need for another extension of 9 temporary district judgeships, including one in my state in Kansas, which has been extended a number of times, which I've had a number of visits from the judges from my district court worried that a vacancy could occur and we might be in a situation where we hadn't extended that and we might lose that, and the dramatic impact that would have on our caseload work in Kansas. And so I wondered if you could provide the subcommittee with more detail about the caseload currently being carried by these particular judgeships. And I know you mentioned some are just temporary, some need to be permanent. I think for a long time we believe that Kansas and a number of the judgeships need to be made permanent. That work's not being done on the authorizing side, and so we continue to, because of the good work of this subcommittee, continue those temporary judgeships every year, almost as if they are permanent. If you could talk about the caseload being carried by those judgeships, the potential impact of their authorizing expiring, and what your recommendations would be for a long-term solution to this problem.
Specifically with regard to the temporary judgeship in Kansas, we have looked at the average weighted caseload there and what the caseload would be if that temporary judgeship was not extended. And it would be 454 cases per judge if the Congress didn't extend that temporary judgeship. So that exceeds the requirement that we have for requesting a permanent judgeship by a good amount. So it's certainly justified in the case of Kansas. There are districts. I said I'd clean this up earlier. It's 8. We have recommended converting 8 of the Article 3 judgeships to permanent status, and 2 we have not. Those would be in Hawaii and Alabama Northern. But it's because without the extension, it wouldn't justify a new judgeship. So, but in the instance of Kansas, it's certainly justified, and we go through a careful analysis of every one of these and present our figures to you.
You know, for the temporary judgeships for which we're seeking conversion, if the temporary judgeship were lost, the case load per judge in that district would range from 443 to an unbelievable 1,200 in eastern Texas. So, you know, every single one of those would put the judges over what's considered to be the expected upper limit of a case.
And what's the net effect of that? What does that really mean for our constituents, for the taxpayers of this country?
It's hard to get the work done. I mean, judges are overworked and overloaded, and they're very conscientious, and they work.
I mean, you'd have civil cases going for years longer potentially, and
Yes.
you could theoretically have criminal cases expire and people be released potentially, right, if you couldn't move the cases quick enough.
I think that courts really very conscientiously try not to have to dismiss a case because of a violation of the Speedy Trial Act. And you can imagine how that negatively impacts the civil docket. Of course, what's in our civil docket is individuals and businesses trying to get their disputes resolved.
Right, sure.
Yes, seeking redress.
Right. Well, I think it's very important, and we need to always continue to highlight that. It's tough work to get those to be permanent, and so the subcommittee's work to continue the temporary judgeships is critical, and so I appreciate your testimony to that fact. One other issue I wanted to raise today, and I serve as the chairman of the Legislative Branch Appropriations Subcommittee, and in that role I oversee the Architect of the Capitol, and so I have special interest in this issue, which is, you brought up the issue of the Thurgood Marshall Federal Judiciary Building facade.
Yes.
Can you explain in more detail the amount of risk proposed by this deficiency, the timeline for completing repairs, and the estimated total cost? And have all possible avenues for recourse against the contractors been exhausted?
Yes, if I could start at the end of your question, sure. Because historically what happened was when the building was built in 1992, I believe it was constructed. There was faulty construction at the time, and it was noticed and brought to the attention of the construction companies, and some remedies were attempted back in those days early on. It grew worse. The marble or the outside of the building is there are weaknesses in it, and there was an assessment of it. Unfortunately, and we brought it to the attention of the architect of the Capitol and the company that constructed the building, unfortunately, went bankrupt, and so there was no recourse for the architect of the Capitol to seek reimbursement and legal recourse against the construction company. And yet the risks are very great to not only those who work in the building, but the public who walk around it for pieces falling off. It's very similar to what happened, I think, at the East Wing and the National Gallery of Art. As you may recall, the reconstruction that had to go on there on the outside of that building. So we've worked closely with the architect of the Capitol. They're, as you've pointed out, they don't have the ability to seek monies in their budget from the appropriators under their jurisdiction. And so it falls on us to seek it. And it's no fault of our own, but we're stuck with the ones, being the ones that have to ask for the money to repair it. And it is urgent. As to the timeline, we're working on getting it remedied as soon as possible. I don't have an outside time frame for that just yet, but we're working on it.
Thank you for your testimony.
Thank you.
Thank you, Chairman Yoder. And if Judge, you and the Director still have a few minutes left, there may be some remaining questions. I'd like to turn it over to Ranking Member Quigley if he has any.
Well, just one. The jury attendance fee hasn't been raised since, I think, 1990. It's at 40. I believe you're asking for a $10 increase. Can you elaborate why this is a good idea?
Well, if you think about $40 a day, jurors are protected statutorily from not losing their jobs, but there's no obligation on the part of employers to pay them while they're on jury duty. We have cases that are complex enough that jurors sometimes aren't just serving for a day or two.
Yeah, then the grand juries as well, right?
That's right.
They can go on a long time.
$50 wouldn't adequately compensate them either, but at least it would be a gesture that when we tell them their service is important and when we tell them that they are critical to the administration of justice, it's a bit of a gesture that we mean it. I mean, if you think about a court day is generally going to be at least 8 hours and often 9 or 10. And jurors are being asked to do something that's unaccustomed for most of them. I mean, they are being asked not to pay attention to a television set, but to pay attention to testimony, often complex, to make decisions about facts, to apply law that is often complicated, and to decide with respect to a criminal defendant whether he's guilty or not guilty, and in civil cases to decide liability and damage issues and who knows what else is involved in the case. I mean, we are asking them to do something that is very important and that involves considerable sacrifice on their part, and we would like to make the gesture of saying, you know, you're worth a little more than what we're paying you. Understanding that the committee cannot approve compensating them for what they're really worth.
I concur. Thank you. I yield back.
Thank you. Mr. Cartwright, or Mr. Serrano, I'm sorry, I didn't see you come back. Mr. Serrano, any final questions?
As you both know, I have a great interest in Puerto Rico, and I have had numerous meetings with your colleagues from Puerto Rico about their security concerns surrounding the Atorrey complex in San Juan. So I was pleased to see that this year's request for the Judiciary Capital Security Program includes funding to help address some of these deficiencies. Could you discuss a little more about how these changes will improve security for judges and the public? Also, do you anticipate further funding needs down the road?
Well, the security interests are paramount, of course, in these facilities, and we really do try to focus on those, and I think it is a high priority for us, and I understand it is getting proper attention in Puerto Rico now, and we seek additional funds for that purpose. I don't know that there isn't more in the immediate needs, but possibly.
Thank you.
Thank you, Ms. Serrano.
Puerto Rico it's not high on the list, but it was just placed on the courthouse priority list, that's a part of our plan. So it's all, that's in the future too.
Great, thank you. And I should note that Mr. Serrano has many great years of service on this committee and was former ranking member as well. And glad you're still on the committee. But I know you've moved on to another committee as ranking member. Mr. Cartwright.
Thank you, Chairman Graves. I want to talk about probation and pretrial services. I saw your FY18 congressional budget justification discusses how these services help judges tailor release conditions and sentencing options based on individual circumstances. We talked about it a little bit earlier. Attorney General Jeff Sessions just instructed the Department of Justice prosecutors to seek the most serious charges. My question is, what effect do you believe this reversion of policy will have on the vital work being done by the probation and pretrial services of the judiciary? Starting with you, Judge Gibbons.
I'm not sure that I see it having any substantial impact on the probation and pretrial services offices, except ultimately if people are doing longer sentences, there might be some delay in their getting out of prison. But it's not even sure that if prosecutors seek a conviction on the most serious charge, that there would be a conviction and that the sentences would be higher. I mentioned earlier that judges do have considerable discretion under the guidelines. We do still have the mandatory minimum sentences with us, and the Judicial Conference has been consistently opposed to the mandatory minimum sentences for a long time, but they are still with us. But that's no different from where we were before, except that the new policy does say to charge the full amount of drugs, and I'm not aware to what extent that wasn't happening previously. So I'm not able to say that there would definitely be an impact.
Well, on the same subject, do you anticipate the courts will be capable of dealing with a presumably increased workload resulting from the new guidance?
I indicated earlier I thought there would ultimately be some resource impacts. And if I had to speculate, I'd say certainly there'll be an impact. But we're unwilling to, I guess we're advocating a wait-and-see approach until we determine. I'm leery personally about requesting resources before you really know what it is you need. When in the 2005, when the Supreme Court declared that the guidelines were not mandatory, there was a lot of expectation that we would need additional resources. And back then, money was more abundant. Our appropriators suggested to us perhaps we needed a supplemental appropriation. We asked for one. We didn't need what we'd asked for. And I found it
I was chairing the committee at that time. I didn't like to be put in that position with respect to our appropriators. I wanted to be the person who's told what we in fact know we need. And so I didn't want a repeat of that. And I'm not the only person driving this decision. I mean, this is a collective decision, but that's the way I feel about it.
Well, thank you for that. I want to follow up with increased funding for probation officer training. What kind of impact do you think that would have on the judiciary, both practically and financially? And more specifically, do you think spending money on programs like that will ultimately provide savings in the long run?
If we've just been through on the Budget Committee a process of asking some tough questions of the probation folks. And the reason we asked those tough questions was that we had questions about the amount of money we were being asked year after year for evidence-based practices in the probation supervision. And we weren't sure we understood why it was requiring money every single year. So we had a briefing, and here's some of what we found out in a nutshell. These evidence-based practices are research tested, and there are 3 prongs, and since I haven't found my notes, I'm hoping I can remember what they are. But the first is how you assess the risk, and the second is how you assess the needs of the individual to be supervised, and the third is how you are trained to supervise a person in order to get a better result, given their degree of risk and given their needs. If you do one of those 3 things, the research shows you'll have a 3% decrease in recidivism. If you do 2 of them, you experience a 23% decrease. If you do all 3 of them, 33% decrease. I mean, that's pretty convincing evidence, and each of those steps requires a lot of training of probation officers. We've done 1, we're moving through 2, and we're going to move to 3. And so far, the results we've gotten are pretty much in line with what I said. And so we're going to continue asking for funds to support this additional training until we get to the point where all of our officers know how to do all 3 of these things as well as we can get them to.
Good answer, Judge. I yield back, Mr. Chairman.
Thank you, Mr. Cartwright. Mr. Bishop, any follow-up questions?
Yes, thank you very much to Judge Gibbons and Mr. Duff. As an attorney myself, who has a great deal of respect for the legal profession and for our constitutional system of checks and balances, I, along with a number of others, are extremely troubled by some of the President's comments that have been directed to the judiciary. I'm not going to detail the instances, but I think that most of us are aware of them because they've been broadly disseminated. I'd like to ask both Judge Gibbons and Director Duff what impact you're able to ascertain from your perspective, that these comments have had on the morale of the people that you work with in the judiciary and the judicial branch, and whether or not you believe that this kind of rhetoric will ultimately undermine the legitimacy of the judicial branch in the eyes of the public and go to the heart of our democracy in undermining belief in our system of checks and balances.
Well, as far as effect on the judiciary, I don't think critical remarks of any type have an impact on judges. I mean, we have to know from day one that people are not going to like our decisions. And so we have to deal with that. I mean, it's a constant factor. to some degree, we're public figures, particularly the district judges who are more visible. People are going to say things. Nowadays, people post things on the internet. You know, and so sometimes I Google myself with trepidation to see what I've done recently that upset somebody. And, but you know, you just learn, you better learn early on to let it slide. I mean, roll off your back, because, you know, your job is to decide independently without regard to what somebody else thinks, whether it's a political source, an influential source, or not. And so that's the attitude with which judges approach it. I would hope that there's no effect on undermining confidence in the judiciary as an institution. But if there is, the only thing for us to do is to keep on acting with integrity, to keep on deciding independently, and to hold our heads up.
Mr. Duff?
My 2 cents worth.
I agree with Judge Gibbons' articulation of it, and I think the independence of the judicial branch has always been, and I hope always will be, important in our form of government.
Thank you.
Well, that's a good place to stop. Well, Judge Gibbons and Director Duff, thank you for not only your candid but forthright responses to the questions today, and I know it's a wide variety of topics were discussed, but you're very well prepared and thorough. Thank you for that. And you can be assured this committee will work hard and hand in hand with you as we go forward the next days to really evaluate all your requests that you've made, and we appreciate the work and thought you've put into that, and to do what we can to make sure that you have the resources necessary to carry out your responsibilities that are given to you through our Constitution. Wonderful.
Thank you.
Yeah, wonderful. Well, thank you very much. And with that, we'll bring this to a conclusion. Thank you.
Mr. Chairman, I have an elaboration on a point that
Sure, go ahead.
Congressman Serrano raised. I can mention it to him independently or on the record, but it's just more detail on the Puerto Rico courthouse situation and funding that we might be seeking for security there. It was a study and a project underway to see if there's another phase of security needs that needs to be met, and that study is included in our budget request for 2018. But just to follow up on that point again.
Great.
Thank you. It's always good to follow up. In my case, on Puerto Rico.
Thank you for your indulgence,
Thank you.
Mr. Chair.
Thank you, Director. Thank you.